Joe Gentry, 8750603. Are you Mr. Anderson?
Yes, sir.
All right, very good. And then are you with the AG's office?
Yes, I am.
You have been here several times, so did you get her name? Hi, how are you doing? Got a new court clerk today. All right, so this matter was originally commenced almost 2 years ago, I believe, by a petition for writ of habeas corpus. And then there were several filings and a couple of appeals, and the last appeal, I guess it went up to the Nevada Supreme Court, and the Supreme Court, I guess, reversed a judgment of dismissal by Judge Bayless, and then the matter was transferred to me, and looks like the Supreme Court is anxious for something to get done here. So why don't I check with the, and I appreciate the AG's office showing up here today. I think the minute order said, and it shouldn't have been characterized this way, that I ordered the AG's office to appear. Obviously, I don't have that authority. So I wanted to thank you for being here and helping us as a friend of the court to explain what's going on and how we should proceed.
Not a problem. Your Honor, under NRS 34720, there are two types of habeas petitions that an inmate can file. There is one that challenges the underlying conviction, the underlying judgment. There is the second one is a time computation challenge.
Right.
And that challenges the way in which the Nevada Department of Corrections applies his sentence and keeps records of the days in which, the literal days in which he is incarcerated.
Okay.
There can't be a petition that challenges both. It has to challenge one or the other under the statute. The petitions under NRS 34745 are not treated as traditional motions, so that they are not, once an inmate files the petition, an automatic response isn't directed. It's actually under NRS 34740 that it's first reviewed by the court. The court then determines what's the appropriate response, if an appropriate response is needed, and directs the correct agency within 45 days to file then a response.
Looks like that wasn't done here, and there is a dismissal. It was either on grounds of lack of service or lack of appearance. I couldn't really tell. Like I said, there's a lot of things that have happened in this case without the state's involvement.
Yes, Your Honor, yes. And really what ultimately should have happened is if this court or if another court determined an appropriate response was needed, an order should issue, and then the order gets served on either the AG's office or the DA's office, depending on what type of petition it is. In this particular instance, Mr. Anderson is not challenging the time in which NDOC is computing the days that he's incarcerated under NRS Chapter 209. He's actually challenging the constitutionality of the statutes that he was convicted under. And in his underlying criminal case, the prosecuting agency was the district attorney's office. So I would request that this court, to the extent that it deems that a response is necessary, that it would issue its order directing the DA's office to respond. And I did speak to the District Attorney, John Nyman, who is here today, and Attorney Nyman agrees that this petition is challenging Mr. Anderson's underlying conviction.
They're not challenging the conditions of incarceration, because that would be the AG, right?
Yes, the conditions of the confinement is...
It's 116 pages of petition. I haven't read the whole thing.
Right. So he's challenging the underlying statutes, essentially arguing that the way in which Nevada enacted its statutes was unconstitutional, the process. So that's not the conditions of the confinement would go to the AG's office, and I would direct that to our NDOC department. However,
do we know if the DA's office was served, or it appears that they're here and they're going to go ahead and take a look at this file and at least accept jurisdiction at this point in time. Is that essentially correct?
That's correct. I can say that the district attorney's office wasn't ordered to respond, but in a minute I can try to clear up some of what's going on here as well.
All right.
Once
All right.
council's done.
Thank you. And Mr. Anderson, I will get to you in a moment here. I'm just trying to untangle what happened in the past, so we can move forward. All right, go ahead.
Okay, and so in this particular matter, going through the petition, it looks like Mr. Anderson is challenging the constitutionality of the way Nevada enacted its statutes. That's challenging the actual judgment, and it's not challenging, he's not stating the Department of Corrections isn't applying NRS 209 correctly. He's challenging his actual judgment. Therefore, I would request that the DA would take over this matter. I assert that it's not an AG matter. And I would like to point out that Mr. Anderson does have a petition challenging his computation of time. That's being handled in another department.
Okay.
That's something we would respond to, and that's something we're handling, and I believe his hearing is in March.
It's the 20th of this month.
Yes.
All right, what department is that in front of?
I have a response to that. Excuse me, Your Honor. First of all, thank you for allowing me here today.
Yeah, no, I'll give you a full chance. I just first wanted to hear from the AG, then the DA, and then you. I just need to know if you know what department, what judge that other matter's in front of.
Can I get the...
Oh, you're locked up there?
Yes, sir.
All right, well, you know what, I'll hold that thought, I'll get back to you on that.
Okay, because
All
I
right.
got the department, and I did have a motion, because the AG totally agreed with me on the computation of time, and I did have a motion that I
Okay.
wanted to file in court
Yeah.
today.
I just wanted to confirm, I accept your representation, just want to confirm it's not in front of me.
Yeah.
Because I did see a motion to consolidate in the file too, and again, it wasn't clear which two actions were being consolidated in front of me.
Your Honor, there was recently a department change, so time computations were all in front of Department 7. And it was this week actually, that there was a department change, and now Department 10 will be hearing all of them.
So it went from 7 to 10.
Yes, so now Department 10 will be hearing Mr. Anderson's
Okay.
time computation matter, and any related type of motion should go into that department and stay under that matter, just so we can, well, personally, I actually am the one that responds to them, so that I respond to all of them.
Great, so the AG is going to handle the challenge to the time computation writ. In this matter, the court releases the AG from any further participation or obligation, and we're going to turn this over to the DA's office then. Thank you very much for coming in and
Thank you,
explaining
Judge.
this.
Thank you very much.
All right,
Thank you. Do you have a preference, Your Honor, if I argue from here, from the podium?
wherever you're comfortable.
All right.
All right.
So I agree with
Let's
everything.
don't get into substance, just the procedure at this point.
Sure.
Procedural status.
So the procedural status is essentially, we've determined now that this is a matter for the district attorney to respond to.
All right.
As counsel said, there's basically two types of petitions, and I think that the reason that this was confused is because on page 2 of the petition in big bold letters, Mr. Anderson says that by virtue of this writ, suitor is not attacking the judgment of conviction, which means that it would be a grievance or a time bar petition, except he then for the rest of his petition goes on to argue that the statute is unconstitutional and is attacking the judgment of conviction. So from the face of it, it looked like it was an AG matter, but it's actually not. It's a district attorney matter. So there's a couple of things that the court can do at this point. If the court wants to issue an order for the district attorney's office to respond, we'll respond to it. I think it's 30 or 45 days.
I think we got to move a lot quicker than that. I'm really concerned because this matter has gone on for a long time, and I'm sure the Supreme Court's going to want quick action.
Sure.
The writ's been pending for a couple of years, and so the inmate probably should be granted some leeway, given that he didn't understand the
Correct.
nuances of it.
To the extent that Your Honor wants to move quickly, I'm prepared to respond to the merits orally today if you don't want to do it in writing, so I can explain, I guess, the merits of this petition, or at least the procedural posture that we're in.
Yeah, well, let's still hear about the procedural posture, because I think after I hear both sides, I am going to want to move forward with some kind of expedited resolution.
Sure.
I would like it to be in writing rather than orally, because then Mr. Anderson can get your position in writing, and then he can have one last chance to respond before I have a final hearing here.
Okay, yeah, then to the extent that we're gonna do writing, I mean, the procedural posture is pretty much what I just said, so if the court
Okay.
wants to order us to respond, we'll be happy to do so.
So, all right, Mr. Anderson, let me talk to you for a moment. Thank you. What we have here is a situation where the AG's office is taking a look at the file, and this is a matter that should be handled by the district attorney's office. Apparently, your action was dismissed by the prior judge for some reason, and I think it was the judge's contention that he thought the AG wasn't served. All right? Turns out it wasn't the AG that needed to be served anyway, it was the DA's office. So we have the DA here. The Supreme Court, granted your petition to send it back here and for us to get a move on it, okay? So, but basically you're saying you shouldn't be incarcerated because the statutes under which you were convicted are unconstitutional. Is that your position?
Not exactly.
Not exactly. Well, tell me just in a couple minutes.
First of all, the face of the document does not say habeas corpus for writ of post-conviction. It's a habeas corpus, which is the correct vehicle to use to address this issue. It does not say post-conviction. If I use post-conviction, the state will be allowed to add latches and time bombs. But we didn't use a post-conviction. We used a regular habeas corpus, and it does not attack the judgment of conviction. What this habeas is attacking, Your Honor, is addressing was the unconstitutional creation of Senate Bill 182, which is a violation of the Separation of Powers Act, Nevada Constitution 3 and 1, which also violates Nevada Constitution 6 and 11, dual services. That was basically a lot of things in one, trying to be quick and get directly to the issue at hand. As far as this writ is concerned, we never attacked the validity of the judgment of conviction. This writ was between citizen and state, and I was redressing the government after we did several years of research. The courts first found that the defendants weren't served, which defendants had been served, and then it went back to the judge who originally dismissed it. She dismissed it again, saying that they weren't served after we proved through mailing documents from the prison that they were served. Well, those same mailing documents were sent to the Supreme Court, and the Supreme Court, the first time, this is the second time it's been in the Supreme Court. The first time the Supreme Court reversed and remanded for the same exact reason. They said that the AG nor the DA was served, which was very incorrect. So the second time we went back, we sent all of the documents to the Supreme Court, which if your court needs a copy, I do have them here with me today.
I have all that.
Okay, and the Supreme Court sent it back to your courtroom for proceedings, which I would like to clarify. I don't owe allegiance to the NRS system. The NRS system was designed for quick access with the courts.
Yeah, no, I understand. You explained your position well in the papers. I'm going to take another close look at that.
And second, the consolidation paperwork that I sent in, the Attorney General's office totally agrees with my position as far as I caught this case in 1999, and I was supposed to get 40% off the front and 40% off the rear, according to the laws during the time when this crime allegedly took place. Well, I never received the 40 and 40, which when I did the
right,
writ,
that's the subject of your other writ?
right, which when I did the writ, I informed, even in my plea deal it says, if the defendant accepts this deal, 40% of his minimum term should not exceed 40% of his maximum term. Well, 6 years is what it takes to clean up 3 to 12, and the DOC.
So, yeah, I'll give you one more minute. We got to kind of.
Well, to make a long story short, they never applied the 40 minimum and 40 maximum to my sentence. Now they just applied it to the second sentence. And if you will allow me, I have a motion that I would like to file in open court because the hearing is coming up on the 12th. And I just got the response back from the DA or the AG yesterday I did the writ last, the response.
So
last
hold on
month.
1 second. So, there's two different writs. The one in front of me, what are you asking for?
The
What's
one
the
in front of
relief you're
you-
asking for?
the
What
one
do
in
you want
front
me
of
to
you-
do?
The one in front of you, I'm asking the court to consolidate, the writ for my days, the challenge to the unconstitutional creation of Senate Bill 182, and I had a medical lawsuit against the state that I wanted all to be in front of one judge because I was sick for 5 years and they never gave me any medication. Doesn't need to hear nor there, but I was asking that you consolidate all three of those cases.
Okay, so hold on a second. I'll give you just one moment. I need to answer one more question. Just talking about the one writ now, which challenges the constitutionality of
Senate Bill 182.
Senate Bill 182.
Yes, sir.
On that petition only, what are you asking me to do?
I'm asking for relief on that.
What is the relief you want?
The relief that I sent to the courts in the consolidated, we can put a gag order on the case. It don't have to go public. I wouldn't file a motion for the arrest later on down the day, down the line. I'm asking the court to grant me my days that they owe me in the other writ and make a settle.
So you want me to declare the statute unconstitutional?
Yes, sir.
Because you're saying that will affect your time computation in the other writ?
Yes, sir, Your Honor.
All right.
That's exactly what
All right, now I understand a little bit better what you're asking. Let me go to the DA and see what their position is on the procedural, on the procedure going forward.
Sure. So, I think the main problem with computation is, as counsel said, you can't file both types of things in the same writ. One, now the district attorney's office is going to respond to. The time computation petition in front of a different judge is clearly an attorney general issue, and a medical issue sounds like a civil case.
Well, that's not in front of me. So what do we do?
Right.
So he wants me to declare the statute unconstitutional.
Sure.
Now, does he have standing to do that? He's not trying to do that because it affects his conviction, but he is trying to do that because it affects his time computation. So shouldn't this all be rolled over into the time computation writ, and because the constitutionality is a predicate determination to calculating the time?
It's a good question, and I'm not entirely certain what Senate Bill 182 actually did.
Okay.
If it does, I suppose. My understanding in reading through the petition was that he was saying that the laws that he was convicted under were unconstitutional,
Yeah.
which does attack the judgment of conviction.
I thought that's what he was doing, but he just clarified that today.
Correct. If Senate Bill 182 is a computation of time statute, then maybe it is an attorney general issue? I don't know.
Again, I also don't know what Senate Bill 182 did. I also read it in the same way the court read it, is that he was challenging the statutes in which he was convicted under, which is a totally separate and apart statute in the way that NDOC computes time. The way NDOC computes time is actually under NRS Chapter 209. That dictates exactly how NDOC calculates a time that an inmate is incarcerated and taking those days and applying it. So Mr. Anderson mentioned a 3 to 12. That's a minimum of 3 years and a maximum of 12 years. Now he's serving time, and those days, depending on what type of offense was committed or he was convicted under, those days apply differently. Sometimes they apply to the minimum, where he can go in front of the parole board earlier than 3 years. Sometimes it doesn't apply to the 3 years, and it applies only to his maximum. Then there are statutes. He was discussing the 40%, and the statute escapes me now with the 40%. But that's not how NDOC computes the time. That's the underlying sentencing statute cannot exceed 40/40. And typically, that I've seen in a lot of petitions, in fact, 100% of the petitions that I personally have responded to, the sentences have always added up to 40/40. Now, that involves me actually responding to Mr. Anderson's time computation challenge. However, SB 182, 182, I don't know what that bill did. I don't think that it's something that NDOC itself is subject to as far as calculation of time and applying his statutory days his meritorious credit days, his work credit days, and then the actual flat time. Flat time is when there's 30 days in a month, the inmate gets 30 days. In addition to the 30 days, so long as there are no grievances against the inmate, he gets 20 additional days applied to his maximum.
Right.
Then if he works or if he completes a program, those again apply to his maximum.
Right.
That's,
I'm familiar with that generally, because I did the felony conviction sentences for about 2 years. I'm not doing it now, but
okay.
yeah, so I'm
Yeah,
pretty
so-
familiar with that.
Right, so those that NRS Chapter 209, if Mr. Anderson is not challenging those parameters, then I would say it's not an AG matter, and I would also object to a motion to consolidate for judicial efficiency. All the petitions that are challenging time comp are heard in Department 10. Hearings are not had, so the AG doesn't appear, neither does the inmate, and this is for purposes because we get hundreds of thousands of them, because the Southern Nevada has High Desert, Southern Desert, and it has Florence McClure. So we get a very high volume of these types of petitions. For that purpose, they are heard in Department 10 only, and hearings are not held, inmates are not transported. The AG, in fact, does not appear. So it's something that we file a response to. The inmate can file a reply, and the judge decides the matter on the pleadings.
All right, so question for the DA. Under what circumstances would there exist for you to still be involved in a proceeding in this case that's challenging the constitutionality of the Senate bill?
Well, so again, assuming that Senate Bill 182 has something to do with actual time computation and not the conviction itself, I don't think that the DA's office would have anything to do. I feel like we're a little bit back to where we started at the beginning, because I'm not entirely certain what it is this is doing, but I'm accepting Mr. Anderson's representation that this is a challenge
So hold
to
on
a
a
statute that affects computation of time.
Senate Bill 182. Tell us your understanding of how that applies in this case.
Yeah, first of all, the unconstitutional creation of Senate Bill 182, not only does it affect the computation of time, but it affects any NRS that it touches. Seeing that the state did not make the court aware that NRS 209-4465 addresses the year that you caught your case, which would be the ex post facto violation. I caught the case in 1999. Up until July of 2007, the state can only charge me with the laws that were in effect in 1999. They cannot charge me with the laws that were in effect from 2007 and after.
All right.
So that's where that computation of time comes in at. The state did not compute the time correctly. And to your main question, Your Honor, the creation of Senate Bill 182 was not a constitutional act. And an unconstitutional act cannot create an office.
All right. So what we need to do is, this is a similar argument that I've seen raised by many inmates, and I know this has gone up to the Supreme Court, and the Supreme Court has determined that I think this was an enabling act that authorized the legislature to enact the various conviction penalties. All right? And so what we need to do first is to consider if I should transfer this to Department 10, because ultimately this whole thing gets down to how much credit you should get for time served and good time credit and education credits and all that. All right? And I know you're challenging the constitutionality of the statute that applies in calculating those things, right? But that really has to be decided by Department 10, I believe.
Your Honor,
Anybody disagree?
I would agree with the court that based on what Mr. Anderson just represented, he is presenting an argument that was decided by the Nevada Supreme Court in Williams v. State, and that was a time computation issue, and it depends on, under Chapter 209, it depends on when the offense date was committed as to how certain credits get applied. If Mr. Anderson is representing to the court that that's the extent of his argument, then I would agree that this particular petition would get transferred to Department 10, and then I would respond to both his time computation and this particular petition.
Sounds like that's kind of what you want anyway. You want these to both be consolidated, and it should probably go in front of the judge that is handling the computation matter.
I partially agree and I partially disagree, Your Honor, because I do not want the Senate Bill 182 to lose. I don't want to lose my challenge to the state on the unconstitutional creation of Senate Bill 182 because the state already agreed that I was correct as far as the computation of time goes.
Well, Department 10 will have to decide it. Right? I don't know why that has to be in front of me.
No, I'm not addressing the computation of time. I'm addressing the issue before this court. If you consolidate it, will the unconstitutional creation of Senate Bill 182 be affected, and will that be heard? With the consolidation, that issue would basically not even be heard anymore.
No, I see your point. All right, so I guess it is possible that Department 10 would not look at the constitutionality of Senate Bill 182 in making its ultimate determination. They might just avoid that issue. Why don't it's a legal issue which is not going to require the taking of any evidence. I can resolve that pretty quickly by studying all of the statutes and the constitutional provisions that you cited. What I want to do is give I guess this would be the DA then, right? If we're just looking at well, would it be both of you? Because if it stays in this court on a petition for writ challenging the constitutionality of the statute and not the conviction, all right, and not terms of incarceration, then I could see how both the DA and the state would have an interest in responding. Perhaps it would be the DA's position that the defendant does not does not have standing, so you'd want to do a motion to dismiss. And then perhaps the AG's office would want to express its position on the constitutionality of the statute, since that's generally their purview. Response, counsel.
Well, so if, and I'm just using a hypothetical, this has nothing to do with the case, but if what Mr. Anderson was saying is that the robbery statute was unconstitutional and therefore he was wrongly convicted of robbery,
I think that's part of it.
then, well, okay, so if that's part of it, then we can respond to that. But if what he's saying is that Senate Bill 182 affects how time is computed and 182 is unconstitutional, therefore the time should be computed differently, it wouldn't be a district attorney issue at all. If the crime is being declared unconstitutional, then it's a district attorney issue. If it's just the amount of time, but the conviction on the underlying crimes is held to stand, then it is truly not a challenge to the judgment of conviction.
So the problem we're having here, I know we're spending a lot of time here. The problem we're having here, it's over 100 pages, this petition. It's convoluted, perhaps because this matter has a convoluted history. And neither one of you have had a chance to read it yet. You're just responding kind of to hypotheticals here. So I understand that. So we need to, one more time, get to the crux of what you're looking for. Just answer me very simply, Mr. Anderson. Are you seeking just to affect the computation of time, or are you just seeking to affect your judgment of conviction, or both?
Both, Your Honor.
All right. So it is both. So go ahead. Looks like you were raising your hand.
So, I mean, as counsel said at the outset of this, you can't do both at the same time. He would have to file separate petitions, and so this should be dismissed because it's combining both of the issues. You can either challenge
Or I
the
can
judgment.
excise the part that shouldn't be in front of me.
Sure,
Yes.
that would work as well.
And then don't post-conviction writs challenging the judgment of conviction, don't those go to the original department where the conviction was determined?
Historically, yes, that has been the case. However, my understanding is that Chief Judge Bell has decided that post-conviction petitions for writ of habeas corpus are now assigned their own A case number. They're no longer tied to the criminal case, which...
All right.
is difficult, but my understanding is that that's not the way that it works anymore.
Very good. All right, so it's in front of me. So here's what we're going to do. To the extent Mr. Anderson is seeking in this proceeding to challenge the time computation, that part of your petition is being dismissed without prejudice because that should be handled by Department 10. All right? So the only matter that's going to remain in front of me is your challenge to the constitutionality of Senate Bill 182 as it might affect your conviction. All right? So what I'm going to ask is for the District Attorney's Office to file a response to the petition or file any appropriate motion to the petition. And I'd like to have that done as quickly within reason as the DA's office can do that.
Sure.
What would you like?
We should be able to get you one in 14 days. It won't be a
2
long
weeks?
motion,
Yeah, is 2 weeks enough? Because there's a lot to study here.
Given the other procedural posture of the case, I think that yes, we can respond in 2 weeks.
Very good. So you'll get it in 2 weeks. You'll serve Mr. Anderson. And Mr. Anderson, it probably takes a few days for it to work its way to you. I'm going to give you a chance to respond to that. How much time do you need to respond to the district attorney's response?
I would need 2 weeks,
All right.
to respond. I want to make something clear. My computation of time is dismissed, or what are we?
It's dismissed in front of me. It's not dismissed completely. It's dismissed in front of me because you have another matter pending in front of Department 10.
Okay.
So Department 10 has to address the merits of that petition, not me.
Well, can I file this motion in open court because?
What motion?
This is,
that Department 10 motion?
This was my reply to their response, that they partially agreed on, but
All right,
under.
Yeah, hold on. So he's got a motion that he wants to file in connection with the Department 10 matter. How do you want to handle that?
Your Honor, I'm actually looking at his time comp. I thought I brought it with me.
Thanks for your patience, Marshall.
I have
Appreciate
it here if you want to see it.
Yeah, so if he wants to file a motion or a reply, that's totally fine, but I'd like it to be in the correct department so that.
Yeah, it's not being filed in this department, but it needs to be filed. I don't know the normal procedure for inmates to file stuff. I think they just send it into, does it just go to through Christensen, or does it go into, how does it?
When it's filed in open court, or?
Well, no, normally if he wasn't here, he would have some procedure to file.
Oh, yes, so he sends it for filing with the court, and
All
then
right.
the court, then we receive a copy.
All
of
right,
it.
but he can go ahead and file it here. I give it to my court clerk. She'll get it filed for Department 10.
Sure.
Is that possible?
I don't know if that's
Okay,
your
she can do
procedure.
that.
Okay.
All right, why don't you go ahead, Marshall, if you can take the paper that he wants to get filed.
Now, I would like the record reflect in this. I know you don't have anything to do with it, but while the state is here, under NRS, under the NRS
Marshall, why don't you-
209-44652B, I also was supposed to be granted 432 days house arrest time. According to your NRS, I was supposed to be granted that, and it never
Sir,
happened.
hold on, that's for a different department, all right?
I'm
We're
sorry.
trying to stay focused here,
Okay,
all right?
okay.
Let me take a look at what he wants to file. All right, looks like there's several pages, a handwritten motion, and several attachments. Counsel, you want to look at this before I have it filed, or you'll get it in due course, right?
I'll get it,
You want a
once
copy?
it's filed, I'll pull it up once I get into the office and.
All right,
take a
very
look
good.
at it.
So, do you have a copy that you want stamped and returned to you?
Yes, I do, yeah.
Well, do you have a copy with you?
No, sir, I don't. That's the only copy. Usually when I send it to the
All right.
court, they send a stamped file copy.
They did?
back. Yeah.
All right.
But I got their response yesterday, and the court date is on the 12th. It wouldn't make it to the court in time for them to hear it.
All right, we'll get this filed today. Thank you. All right, so, just one more time, 2 weeks from today is the date by which the district attorney must respond to Mr. Anderson's petition in this matter, A750603. and then the reply to that response will be due 2 weeks thereafter. Mr. Anderson, do you understand that, sir?
Yes, sir.
And then we're going to be back here for a hearing on that, knowing that, things take time to go back and forth. I wanted to have a hearing in that 2 weeks after the reply comes in, all right? So 2 weeks, 2 weeks, 2 weeks, all right?
Yes,
Do I have, I'm asking permission, if I have witnesses, that,
It's not an evidentiary hearing, just under
I'm
decided.
do I have to subpoena those people to court?
It's just a legal issue,
Okay.
all right? I'll read all your papers,
Okay,
and I'll look at the law, and I'll come
Okay.
in and make a decision, but I'll give you a chance to be heard again, and the DA a chance to be heard. All
okay.
right, 6 weeks from today?
March 20th, 9 o'clock.
All right,
March 20th.
March 20th, 9 o'clock. Thank you, sir, have a good
Thank you,
day.
Your Honor.
Thank you, counsel,
And I
appreciate it.
Thank you.
I assume my office is preparing another order for transport?
Yes, please prepare that
Okay.
order for 6 weeks from today.
Okay.
Thank you, counsel, or thank you, Marshall. That was the most messed up matter I have ever seen. I mean, and it wasn't my fault.
No, it was not your fault, and
We're off the record. Yeah.
I'm not even entirely clear what it is